Hi, students. Hope you're learning and reading a lot about torts now because now you have created a lot of interest in the subject, isn't it? In this class, we will be discussing some important maxims of law of torts, which will be dealing like ex turpi causa non orito action, innuendo, res ipsa loquitur, etc. They are generally used in law of torts along with case laws and their descriptions. Little bit of um, problematic right now, isn't it? But you will get to know what they mean, and then you will just have to mug it up, or maybe it will be just a playful thing, right? So, a maxim. What do you mean by a maxim? First, let us consider that what is exactly a maxim. So, a maxim is a rule or saying or a principle which has to be followed by the society. Maxims are used in various branches of law to make a particular point to understand clearly and provide a proper solution to the case. Maxims are very widely used in law of torts as well. Torts, according to Winfield, can be defined as, do you remember from the previous class? If no, I will repeat for you once again. Tortious liability arises from the breach of a duty primarily fixed by law. This duty is towards person generally, and its breach is redressable by an action for unliquidated damages. Now, to make these rules and principles much clearer, various combinations of Latin and French words are used in the subject. So, out of all those maxims that are very usually used in law of torts, I have picked up five important maxims from law of torts. So, let's begin with the first one. The first maxim in law of torts is ubi jus ibi remedium. What does this mixture of language say? Have you heard it earlier? I think you must have in your LLB days. But you will be get a clearer concept over here that what it exactly means and how it is applicable. So ubi jus ibi remedium means for every wrong, law provides a remedy. Ubi jus ibi remedium is a Latin word which means where there is a wrong, there is a remedy. Now I think you remember it. It is even one of the essentials of law of torts. Where one's right has been denied or invaded, the law provides a definite structure to safeguard the rights of a person. Just means legal authority, demanding or ordering to do something, and the word remedium means remedy. The basic principle contemplated in the maxim is that when a person's right is violated, the victim will have an equitable remedy under law. The maxim also states that the person whose right is being infringed has a right to enforce the infringed right through any action before a court. All law courts are also guided with the same principle of ubi jus ibi remedium. The Circuit of Appeal of United States of America observed in one of the cases known as Leo Feast versus Young that it is an elementary maxim of equity jurisprudence that there is no wrong without a remedy. In a popular case that we have discussed in the previous class, known as Ashby versus White, it was held that when the law clothes a man with a right, he must have means to vindicate and maintain it, and remedy if he is injured in the exercise and enjoyment of it. And it is a vain thing to imagine a right without a remedy because they are reciprocal in nature. So, where there is a right, there is a remedy. In this case, the defendant, who was an officer in the parliamentary election, refused to take a vote of the plaintiff, although the party of the plaintiff won the elections and there was no monetary damage to him as well. Yet, there was a legal damage to the plaintiff, and the defendant was liable to pay him damages. When there is no legal remedy, there is no wrong. Unless and until a proper legal authority to check injustice is there in the society, wrongs cannot be defined, and hence their definition remains vague. So, this is all about ubi jus ibi remedium. in which you can very well quote down Ashby versus White. So here I would like to point out one thing, that in CLAT exam, there can be a question of match the following in an objective type question, and there it can ask you that several options can be given, and it may be asked that Ashby versus White is of which, is relatable to which kind of a maxim. So it is ubi just ibi remedium. And if there is no ubi just ibi remedium, then there can be injuria sine damno. Because in the previous class we have understood this, that injury without damages. So there was no damages or loss or harm to the plaintiff, but still there was a legal injury. So do not forget, Ashby versus White will contain two answers for one question. Ubi just ibi remedium for a maxim 1, or injuria sine damno for option 2. All right. So let's move on to the next kind of a maxim.